the burden versus the benefit analysis. One of the things that you're going to want to do, and that the courts are going to consider if it ever comes to motion to compel or you're there on a hearing, is if you are requesting information that the other side is objecting to because it's inaccessible or very costly, you're going to want to exhaust any other resources that you have to obtain the information. The courts are going to make you go through that process to see if there's least or less expensive means for obtaining the information. The case I cited, the Young case, involved a school district, and the information requested was there was a complaint against one of the teachers, and the plaintiff asked the school board for additional information if there were any other complaints against this teacher for a number of years going back. And the school board objected, saying that all the information during that time period is on backup tapes, and it's going to cost us a ton of money to try and go restore that information and produce those documents. And the court explained, plaintiff, you can go try and depose other school officials, depose other teachers, try and obtain information from the other parents. And the court made the plaintiff go through those steps before it was going to put the burden back on the defendant to try and go restore these tapes. My only hesitation in something like that is you're, in essence, trying to shift the burden from the party to a non-party. So I would raise a little caution with that, and that's what the court ordered in this case. I guess it depends on the specifics of the case of whether or not you want to put that burden on the non-party. And obviously there's going to be a reimbursement of costs in that situation. I know I was involved in a case where we subpoenaed a number of non-parties for information that the other side was not producing, and we ended up having to go through a very detailed meet and confer with the other party and laying out exactly what we were looking for, and all of their information was, of course, held on servers and emails and things like that. And we had to go through a list of search terms for them to be able to search. And there was a lot of back and forth on what those search terms would be. At the end of the day, it's what they consider to be $100,000 to search all the documents. We got down to a very small amount because we were able to narrow down exactly what we were looking for. But nonetheless, the point there is that we did find in that case it was beneficial to go to the third party rather than trying to waste time and money going from other sources from the plaintiff. One of the other issues that the courts are going to consider, what if the cost of the case, or the cost of discovery rather, outweighs the value of the case? And for this purpose, cost involves not just printing out and producing the documents by hard copy or putting them on a disk or a flash drive and the cost associated with that. We're talking about the cost associated with having the attorneys or the paralegals look through and base label and the documents, determine if they're responsive, privileged, confidential, and other things like that. Also consider the opportunity cost for the employer or your client and the employees, the time spent that they have to take away from their business to look through the documents and determine what they need to produce to us. So there's a number of costs that go into this evaluation. In the Mancia case, the issue came up about in that case there was no determination on what the damages in the case were. In other words, what happens in a situation where if there's $20,000 alleged in damages, obviously you can determine if the cost of production would be $10,000, $15,000, $20,000, $25,000. You have an easy comparison to determine whether or not the cost outweighs the value of the case. If there's no damages alleged, or they allege, well, we want damages to be determined at trial, what do you do in that case? And in this case, the court found that you really put the burden back on the parties to go back and determine what the value of their case, what they thought the value of their case was going to be. He told the plaintiff, assume the defendants are going to have they're going to win, there's going to be a zero recovery for you. Defendants, assume the plaintiff's going to win and assume they're going to get everything they want, they're going to hit the jackpot. So that is the range of the damages in the case, from zero to whatever that jackpot number is. And the court then determined from there what the discovery budget was going to be. And he, in essence, went back to the parties and he told them, you should have done this from day one. You guys should have gotten together, determined what the discovery budget should have been, and not wasted the court's time to come in and have me enter an order of something that should have been done from day one. And I think we'll find, for those of us that have been before the courts and seen this, I don't know if there's any judge that enjoys or looks forward to a discovery hearing. The first question you're going to hear most likely is, what have you counsel done to try and resolve these issues? And I would advise you have a good explanation, or you've gone through that meet and confer process, because if you haven't, you're not going to have a good ruling in your favor. I've seen it where the judges make the parties who don't have an explanation literally step aside, go resolve the issues, and not get before the judge again until they have an explanation of what the issues now are.